Outlaw Law is brought to you by Whitaker and Hamer, attorneys and counselors at law. Your law firm for life.
The Outlaw Lawyers, Josh Whitaker and Joe Hamer, Whitaker and Hamer Law Firm. They're the managing partners. They're practicing attorneys here in North Carolina. They have offices conveniently located in Raleigh, Garner, Clayton, Goldsboro, Fuquay-Varina, and Gastonia. And we understand, look, there are legal situations you may be facing and you may have questions. Great resource for you. Call the firm, 800-659-1186. That's 800-659-1186. Leave your contact information, briefly what that call is about, and an attorney with Whitaker and Hamer will be in touch with you. And you can always email your questions to the program, questions@theoutlawlawyer.com. We are going to get into our next portion of the program. Gentlemen, New York State Rifle and Pistol Association versus the Bruen decision.
Yeah, Morgan, I've heard people pronounce this two ways. I've heard Bruen and Braun, so I don't know which way is correct. That was our...
Well, I'm from North Carolina. I look at Bruen and I say Bruen, but it could be Braun.
Well, I always tell people, if there's any way I can mispronounce a name, I'm going to do it. I'm the worst person at pronouncing.
Dude, I'm Ron Burgundy. You put it in front of me and I say it.
Bruen. I don't know why this reminds me of this. This reminds me of you heard of the Mandela effect, Joshua?
Yeah.
Yeah, the Bernstein and Bernstein Bears. I don't know why this triggers that in me. But
tomato, yes.
So over the past week or two, the Supreme Court has been dropping just bomb after bomb on everybody, just releasing all these opinions at the end of their session. And so, of course, the Dodd case that we talked about last segment, that's been the one that's garnered the most attention because it was the Supreme Court taking away a previously a constitutional right that they had originally read into the Constitution, so they're taking that away. Of course, that's always going to be big news no matter what the subject matter. And, of course, abortion makes that being the subject matter makes it even more controversial. But even kind of a bigger decision and kind of the other side of the coin, the constitutional right to abortion as it existed was kind of read into the Constitution, was not enumerated, as we would say. This is the other side of the coin. This is the Second Amendment, your right to bear arms, which is, you can argue about exactly what it means, but it's clearly a right that is, it's the Bill of Rights. It's something that the founding fathers thought was extremely important, so much so that it was, the second right listed there in the Bill of Rights. So I saw a lot of people trying to draw, I saw a lot of people on social media and in the regular media just saying that, we don't have the right to abortion, but we have the right to carry a concealed weapon, and just kind of comparing those two things. But these are two different things from a legal perspective. It's a right that was kind of read into the Constitution, and then there's a right that's clearly laid out in the Constitution. And so in this case, you may remember New York has a very strict concealed carry. New York, Chicago, California, they have very strict state gun laws, right? So you have your federal gun laws, but then states can obviously be stricter. And those are the states that kind of have the strictest gun laws in the country. New York's concealed carry, you had to show, you had like an exceptional need, an exceptional cause to, when you applied for your permit, you had to get references. And the argument here in this case was that a lot of those applications just get denied, and there's no grievance process. There's no appeals process. The state just says, no, you didn't demonstrate, this need, this factor that we need from you. This factor is not really defined anywhere in the statute what it is. And again, if this government official says you can't have one, you can't have a concealed carry permit, then you just don't get it. And that was it. And so that's what this lawsuit came from. They had all kinds of problems with this statute. And Joe, I don't know if you got to read this opinion, but it was kind of short as far as Supreme Court opinions go. But Clarence Thomas wrote this opinion, Justice Thomas, and he kind of threw all the old Second Amendment case law out the books again. It's not really getting rid of precedent necessarily, but he said we're going to examine these laws in a new way. And his exact language on this, I got to find it in my notes. The constitutional right to bear arms in public for self-defense is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. And so he's talking about freedom of religion, freedom of speech. The right to bear arms has kind of been treated differently in case law up to this point, and they're saying no, they're saying this is an express right. And, if you're going to, states, obviously there's limits that they can put on this right, just like any other right, but it needs to be done in a certain way. And so that was, it's kind of a different line of thinking for the right to bear arms, especially in states that really try to restrict that.
Yeah, Josh, we're looking at a 6-3 decision here, and where you have the majority ruling that New York law is unconstitutional. And effectively what the ruling was that that possession of pistols in public is a guaranteed constitutional right under the Second Amendment. And, state licensing on firearms is not necessarily an infringement on that right, as long as the states stay within the what we call shall issue systems, which can only condition licenses upon satisfying objective criteria, as opposed to the may issue systems, which seem to contain more arbitrary evaluations, as opposed to more objectively verifiable criteria. So, an example of objective criteria would be like a standardized background check, as opposed to some of the more arbitrary evaluations that have been proposed that are now being deemed unconstitutional, such as like I think social media evaluations were referenced in that.
Yeah.
But it's basically just an attempt to keep arbitrary infringements of this right from being made into law.
So when this decision came down, I was actually in New York, and so I was watching the local news. I was in upstate New York. I wasn't in New York City, but I was watching the local news up there. And the governor and everybody else in government, it's just this decision, they're very angry about it and very defiant. We talked a little bit ago about what happens when states just don't listen to the federal government. We talked about that on this show. We've got all this disagreement in partisan politics, and at what point do states stop listening to the federal government? And anyway, but neither here nor there. New York, their governor, she was up there, and she was not happy with this, and said she's working with their attorney general, and they already had a new law, and it had a social media component, that you're going to be evaluated, and they put in a grievance process. So if you're denied, it can go to appeal. So they were trying to cater to some of the things the Supreme Court said, but it was good here. There was another quote here from the decision. It is undisputed that the petitioners, so the two folks who got denied their concealed carry permit and filed this action, it's undisputed that the petitioners, two ordinary law-abiding adult citizens, are part of the people whom the Second Amendment protects. And I think that's a good way to think about this. The governor of New York, when she was talking, she mentioned the Buffalo shooting was like 6 weeks ago. So that was that grocery store shooting, which was horrible. And then you had the school shooting, and then since then we've had the 4th of July shooting up there in Chicago area. So definitely troublesome at the least. But I always worry, when something like this happens, it's terrible. We want to stop it. We don't want this to happen. But the first thing everybody does is like restrict how a law-abiding citizen can get a firearm, and that's a slippery slope. And especially nowadays, people don't have to cool off, right? People can just take to social media immediately with their whatever they have on the top of their heads. We had to take negotiations in law school. Did you have to take that, Joseph? Negotiations?
I didn't have to take it. I could have taken it. I chose not to take it.
See, all right. Well, we take negotiations, and one of the things that I picked up in class, especially that you can text and you can email. A good part of negotiation is letting things sit in, right? When you get an offer, right? Say you're trying to settle a personal injury case. There's been a car accident. You're going back and forth with the insurance company. And there's offers made back and forth, sitting on it, not letting some time pass. And I think our professor at the time back in the day said, maybe just write a letter, right? Maybe don't even email. Everybody wants to email. Maybe you just write a letter, and you let that letter get delivered in the mail, and you let them sit on the letter, and you slow down negotiations to think about it. And your knee-jerk reaction isn't always the best idea. And I think that's what here, when something like this happens, everybody's real quick to, we need age limits. We need, whatever we need, or we'll make concealed carries so hard to get that no one can get them. I don't know that that's the answer. I don't know that that helps. I don't think limiting the rights of law-abiding citizens, no matter what the topic is ever the answer. And so, like we said earlier, this is an enumerated right. This was another quote here that I thought was important. It says, nothing in the Second Amendment's text draws a home public distinction with respect to the right to keep and bear arms. And the definition of bear naturally encompasses public carry. Moreover, the Second Amendment guarantees an individual right to possess and carry weapons in case of confrontation. So here, they're defending the law-abiding citizen who has the right to defend themselves in their home. They're also saying in public. And so that's kind of a new thought process. So it'll be interesting to see how the states, most states have a concealed carry process, and most, here in North Carolina, it's definitely not difficult. There's a background check. You got to take a class. And I've done all that. I've got the concealed carry. You don't have yours, do you, Joe?
No, I don't. So I just try to be around you so you can use your gun to protect me if it goes south.
Right, that's right. So you're ripe to be attacked at any given moment. So,
yeah. So and you mentioned knee-jerk reactions and blanket restrictions aren't the play. But I think it's also important to note, this ruling doesn't state that state licensing of firearms and restrictions are on their face unpermitted. That it's actually the opposite of that. They just have to be reasonable. They can't be arbitrary. And I think it's important that we clarify. I think something we and most reasonable folks agree on is the fact that there are definitely a place for restrictions, and I don't think that we would advocate for there to be just be the Wild West and there be no restrictions in place. But it's very important to be intelligent about how we go about that, and you don't want to restrict the ability of good, decent, law-abiding citizens to protect themselves, and because that's specifically what that provision of the Constitution is designed to guarantee. And I think it comes back to previous discussions we've had. I mean, clearly, if you look at our country and you look at the things that have occurred recently and just the sheer volume of mass shootings and things of that nature, I think you would be hard pressed to argue that there is not an issue with gun violence and with issues, events of that nature occurring. But I think, again, we come back to the fact that it has to be a multifaceted, multi-angle approach to solving that problem. It can't strictly be, well, we're going to just throw these blanket restrictions on gun owners and we're going to do all these different things to prevent ownership. That could be a piece of it. It just has to be intelligent. But there's also some other elements that need to be looked in. And again, it's an issue that needs to be solved, but it has to be you got to come at it from various angles. And I do not have the answer to what those angles are. I want to make that clear, but I just think you can't be short-sighted in how you approach, solving that issue.
I know we're coming up against a break, but I have a lot of family in law enforcement, and they used to always tell me, the bad guys don't care what the laws are, and so I would say, hey, the bad guys don't care, what laws New York makes. If a bad guy wants to get a gun, a bad guy's going to get a gun, and making it harder for the regular guy to protect themselves is a difficult one to swallow sometimes. But lots more to talk about. We'll stop talking about guns for 8 minutes and talk about something else.
All right, there you go, folks. Outlaw Lawyer, we will roll on. Josh Whitaker and Joe Hamer, managing partners at Whitaker and Hamer Law Firm and practicing attorneys here in North Carolina. I tell you, a touchy subject, a lot of people in on this. If you have a question about something that you're going through from a legal standpoint, here's a phone number for you, 800-659-1186. That's 800-659-1186. And just leave your contact information, briefly what the call is about. An attorney with Whitaker and Hamer will be in touch. And you can always email your questions to the program, questions@theoutlawlawyer.com. And speaking of questions, we've got listener questions coming up on the other side. You're listening to The Outlaw Lawyers.